Welcome back to the Law and Crime Network. I'm your host, Amy Dash, and I'm here with Ken Belkin, criminal defense attorney. We were just talking about the flow of testimony and how important it is to somewhat entertain the jury. And we've seen a lot of witnesses here, this one that we just saw testify who worked for a mining company, and they're talking about the extent of the finances and the financial condition of Tex McIver. He owns some sort of shares in this company. Just because somebody has investments that maybe weren't disclosed to everybody from the start, how would that support the intent to kill somebody and the motive being money?
Well, look, they're trying to defeat that motive. They're trying to say, look, yes, he owed his wife $350,000, but that's not a big deal for this guy. He had significant interest in a mining company. He had investments that, you know, while not liquid at the time, they were worth something that he could cash out on, that he was, you know, not in a bad position financially.
Yeah, and so then the prosecution is trying to counter that by saying, oh, well, he wasn't working as many hours financially. He started struggling around the time that this happened.
They said he sold off some of his wife's fur coats.
Right, that he immediately did that rather than retaining it for its sentimental value. It just seems like there's so much nitpicking going on here. I mean, it's so much more clear-cut when you have an insurance policy that was taken out like a week before the person was killed. Like, aha, we got it, right?
Yeah, there was no smoking gun life insurance policy taken out a week before her death, you know?
Yeah.
But look, he had that wills and trusts estate attorney that took the stand and said, look, you can't let these assets waste. You have to sell them off now because they depreciate. They go down in value. And I think that, look, he's a smart guy. He's an attorney. He had counsel that advised him to do this. And in these proceedings where they probate wills, you're not supposed to waste assets.
Right.
If you're the executor. And if you're sitting around with these fur coats, you know, this woman's never going to wear these fur coats again. The only value they have is in their resale value.
And he's not going to wear the fur coats, right?
I would assume he's not going to wear the fur coats.
All right, so we heard from a spokesperson who he had hired. And what the prosecution was basically saying is that he had hired this guy essentially to try to bribe the DA and get this case to go away. No money was ever exchanged, but I want to listen to a clip from the spokesperson who took the stand, and then we'll come back and discuss what it means in the context of the case. Okay, so did Tex McIver try to bribe the DA? And if so, why wasn't he charged? I want to also bring in a criminal defense investigator, Charles Mittelstadt. Charles, are you there on Skype?
I am. Good
nice
to be
to
with
see
you.
You again. I have Ken Belkin, criminal defense attorney, with me too.
Hey, Ken.
Hi, Charles.
Charles, does it sound like this was an attempt to bribe the DA to make things go away?
No, actually, what we didn't hear is the cross-examination that took place of Mr. Dickerson. And what became apparent from that cross-examination is that, in fact, Tex McIver never uttered those words, that there was a certain assumption that took place. I mean, what we're talking about here is a success fee, which is not unusual. Now, I think it was probably ill-advised given the fact that McIver's represented to have to pay a broker to plead his case to the DA, Paul Howard. His defense attorneys were more than capable of getting that meeting, but I think he was relying on the fact that Dickerson had a close relationship with Paul Howard. But he's smart enough to know that you wouldn't outwardly make this bribe expression that was presented by the prosecution. So again, on cross-examination, when it is kind of fleshed out as to what the exact words, and I believe in this case, the words matter, and that's what I believe it was Don Samuel who conducted the cross-examination, elicited from Dickerson was the fact that he never actually said, share it. He said you can share it with whoever you want, but he never explicitly said share it with Paul Howard.
Okay, I think we're mincing words here, though, Ken, because Dickerson calls it a bonus. Charles is calling it a success fee. Are you allowed to offer somebody money to try to make something go away with the DA? That just sounds like it stinks of corruption.
I get paid every day to make things go away with the DA, but I am a licensed attorney. I am permitted to have communications with district attorneys' offices. I am permitted to zealously advocate and communicate and negotiate with these offices. It seems very suspect to me that he had another individual who is not a licensed attorney, not a criminal defense attorney, liaising with a district attorney's office. That seems a little suspicious. Now, that being said, there doesn't appear to be any quid pro quo here. Nothing to indicate that, look, he would be giving money to a prosecutor to get them to drop the charges or, give him some sort of leniency.
So are you saying that the money would have to be exchanged with the district attorney rather than this outside broker, that would be okay to offer somebody else money to go talk with the DA?
No, I don't think it's okay. I think it's a bad look. I don't know that it is illegal.
He's not charged with it.
Well, that's what I don't know that it's illegal for him to use someone other than an attorney to liaise with the district attorney's office. I will say this. It is suspect that he had an unlicensed, someone who's not a licensed attorney liaise. And by the way, that person can now be used as a witness, whereas an attorney who negotiates with the district attorney's office, they can't be used as a witness. Attorneys can't be a witness in these proceedings. So he really did himself a disservice by doing this. Yeah,
Charles, do you think that this was just a bad move for him? And considering he is an attorney, why would he do something like this that could backfire, and now we see the spokesperson on the stand?
Yeah, clearly it's part and parcel of the pattern of bad judgment that McIver has exercised from the beginning. I mean, this is just another example of it. But I think out of desperation, and not desperation to avoid because he's necessarily guilty of murder, but just out of desperation to control the narrative, to control the spin, he wanted somebody who had a decades-long relationship with Paul Howard, not to, quote, make the case go away, but essentially to advocate on his behalf. And as you hear Dickerson talk about the case, or what McIver had imparted to him, is Dickerson said, hey, it sounded like an accident, and he sounded remorseful. And I told him, hey, I think I can actually go convey that to Paul Howard to your benefit. So this whole notion, this whole narrative that he, paid him to make it go away, I think is very much overstated.
But how common are these political power plays, would you say?
I mean, I think listen, everybody wants access, and Paul Howard, I can tell you, is not the easiest guy to always get a hold of. I got a case right now, literally, that I'm working with another attorney, and we've been trying to get in front of Paul Howard now for weeks to try to resolve the case. So it's not unusual. Paul Howard's a busy guy.
Look,
he's particularly inaccessible
that's
right
the
now.
Process. You're a criminal defense attorney. You got to get on that phone and work the phone with the DA's office. I don't know that I've ever used anyone that's not an attorney to work the phone with the DA's office. It's a little bit strange. And now he puts himself in a situation where he's turned this guy into a witness.
It just seems that Paul Howard would, and any DA would, want to protect themselves the second that somebody comes to them to try to do something like that. First of all, it might send off warning bells and make them want to pursue the charges. And second of all, they would have to either disclose it later in the trial just to protect themselves and obviously refuse such a meeting if they want to uphold a certain code of ethics.
Well, listen, again, I think we all agree it was poor judgment, but let's also put it in the proper context. This isn't a meeting between McIver and Dickerson that took place in some back alley. He actually met with McIver at his office, at Steve Maple's office, and you also heard on cross-examination that Dickerson thought he was part of the defense team in some fashion. Now, I think it would have probably been better advised if, in fact, Dickerson had this sort of special access to Paul Howard to do that in conjunction, if he was going to do it at all, to do it in conjunction and through, through his attorneys. But I haven't seen a case before where a defendant has independently hired some media consultant to go advocate on his behalf. It's just poor judgment.
Yeah, and he also tried to influence the narrative, as you put it, Charles, in with other ways. He also had hired a PR consultant, Bill Crane, who he had published certain information, then asked that information be retracted so that the accusation is it couldn't be used against him. He also left a message on Danny Jo Carter, his wife's best friend and the driver of that vehicle, on her husband's voicemail, then asked for that to be deleted. In connection with those two episodes, he faced witness tampering charges, but the judge just threw those two out. The judge left in place another witness tampering charge related to Danny Jo Carter, where Tex McIver, according to her, asked her to say that she was not in the car at the time that his wife was shot. Ken, I just want to ask you, why would the two charges related to Bill Crane, the publishing of something by a PR spokesperson, and the voicemail message that Tex asked to be deleted, why would those be dropped but not the one related to Danny Jo Carter?
Well, look, witness tampering is a tough charge to prove. There's really got to be some evidence that you intended to impede the government's ability to utilize a witness in a proceeding. And I think, at the end of the prosecution's case in chief, the defense is always permitted to make what's called a trial motion for dismissal, meaning that they can, get up there and make an application or sometimes submit it in writing and saying, look, even in the light most favorable to the prosecution, they have not elicited evidence that could prove every element of these crimes charged, and therefore you must dismiss those charges. It's very rare to see these applications granted at the end of the prosecution's case. I've had it happen in one trial, and sometimes judges don't even really listen to it. But, they were successful in getting these two charges dismissed, probably just because he made some, hey, please stop talking to the police about this. He didn't make any threats. He didn't offer any money. The man still has freedom of speech. He can speak to his friends.
Yeah, I think it's more about the content. Let's listen to that voicemail and then parse it out.
Tommy Lee is Tex. Sir, let me just be plain. Danny is about to send me to prison. Please erase this voicemail message, but call me right away. Y'all have no idea the problem this is causing. It's innocent, but it's absolutely nuclear for me. Please call me.
And Ken's laughing the entire time. You're laughing what, because of the stupidity of this?
I mean, come on. You're leaving a voicemail where you're saying, please delete this voicemail.
And you're an attorney. I think that's really what takes it to another level.
By the way,
fact that
any
he's an
voicemail
attorney.
or email I receive that someone tells me to delete it, you better believe I'm saving it, I'm making copies of it, I'm giving copies to other lawyers, okay? That is crazy.
Yeah. So, I mean, he could have just said, please call me back. It's urgent.
Yeah.
I need to speak with you.
Yeah.
Leave it at that, right?
Let's be subtle. Let's be brief.
Right.
Hey, it's very important that we talk. Got it.
Yeah.
I'll call you back.
Or, like a deep throat type thing. Meet me at the coffee shop, or meet me behind the train station in the dark alley.
Better yet,
We've got to
maybe
talk.
don't make a phone call. Maybe you just show up at the guy's house.
Yeah, knock on the door. Yeah, exactly. So but the content of the conversation, I think, is important, because he's saying, this is nuclear to me, and Danny Joe's about to send me to prison. Do you think that would qualify for a witness tampering charge? Because there is an insinuation there that he wants her to stop talking to people, to stop cooperating.
Look, for witness tampering, there's got to be more than just like, hey, please stop talking to the police. It's got to be something a little bit more concrete. Some sort of threat, some sort of benefit extended. It's got to be something to show that, like, you're really trying to impede the ability of these people to talk to the police. And by the way, no one has to talk to law enforcement unless they're doing so, under some sort of court order. So
are you saying you're allowed to say to cooperating witnesses, stop cooperating or stop talking to the authorities?
You can negotiate.
If you are the subject of the investigation?
Look, you can't threaten. You can ask. There's nothing wrong with asking.
You just can't say, if you stop talking, I'll give you $100.
Oh, yeah, though that's a big problem. That's witness tampering, that's bribery, coercion potentially.
So you can say, please don't turn on me. Please stay on my side.
I had a case, I'm obviously not going to use the guy's name, but he got caught with some marijuana. Not a lot of marijuana, a decent amount of marijuana, enough to get him arrested in New York City. He's pulled over, he says, hey, could I just give you cops like a couple $100 and you let me go? And they go, oh, okay, well, come back to the station. Let's talk about this. They bring him back to the station, and little old, violation marijuana possession turns into a felony bribery case.
Wow.
Because of an innocuous statement like that.
Wow. And so let's go into that other witness tampering charge, though, because when he has a PR person publish something and then says, you know what, I don't like what I said, I don't like the way that it came out, or maybe it was taken out of context, let's retract that. To me, that doesn't come off as a witness tampering charge. So why would that be brought in even in the first place?
No, look, prosecutors like to overcharge. I see it in almost every case I'm retained on. They add charges on that they cannot prove beyond a reasonable doubt, but they do it. It bolsters negotiating positions. Also, you know, prosecutors have an incentive to look at the case through the lens of this guy is guilty, what do we have that we can throw at him? And they want to get someone. The more charges they add on, the more charges the defense attorney has to do away with and deal with, and, you know, the more likely that they're going to get some sort of conviction here.
Right, because they have more leverage.
Yes.
Right. So when we were listening to the Dickerson testimony, what he was saying is there was some sort of dispute over whether Tex McIver mentioned Black Lives Matter. This has come up before, and the allegation was that he had said, oh, maybe there's some Black Lives Matter people here, and that was one of the reasons that he had asked his wife to hand him the gun, because he was scared not only about homeless people in the area, but also about Black Lives Matter. We know there were 3 black people on the jury. Is this just an inflammatory angle here by the prosecution where they're trying to paint this guy as a racist and sway the jury that way?
I don't know. Look, a lot of my best friends are supporters of the Black Lives Matter movement. I'm a supporter of the Black Lives Matter movement. I don't think anyone who's not a supporter would feel like they need to have a gun to be around me or my friends.
Yeah.
Well, maybe some of my friends. But
yeah, but I mean, but does it matter? Because now we're going into the testimony where this guy Dickerson is saying, well, he told me that he never said it, because he's hiring a spokesperson to sort of correct things for him. So he's trying to correct this whole Black Lives Matter angle.
I think this guy needs to stop hiring PR people and spokespeople and listen to his lawyers and do what his lawyers think is best.
Charles, what do you think the relevance is of that whole controversy over whether he mentioned Black Lives Matter or not?
I do think that there's it is an attempt on some small level to kind of weave in a little bit of a racial component to this. There was some testimony about this mention of Black Lives Matter, but listen, it's no different than any other sort of gathering. I mean, it seems like the predominant concern that he expressed was immediately upon waking up, finding himself unexpectedly on this off-ramp that was not part of the plan. And this homeless population that's there. And by the way, I've retraced the route with Vinnie Politan. The very night we went out there, there was a significant homeless population precisely underneath that overpass. In fact, the Atlanta Police Department was there dealing with them for about an hour while we were there. So it is a real thing. But in terms of the Black Lives Matter, it could be something as simple as, look, it's a gathering. It's a bunch of people. He didn't expect it. And he's just awoken from his sleep and finds himself there, and just out of an abundance of caution, he says, you know, hand me the gun.
We had Vinny on, and he took a very different perspective than you. He said that the area, right, is not very dangerous. We know, just as a disclosure here, that you were very close with Tex McIver's defense team, and you are, you know,
I'm a defense investigator. So
I was just going to say, you position yourself as
try to be unbiased.
A criminal defense investigator. Would there be a valid objection, Ken, to even the introduction of this whole Black Lives Matter? And what is the relevance?
Well, that's the thing. I would object to it. I don't see the relevance here. I think it's more prejudicial than probative, which is the standard for relevance.
Right.
You know, it has the effect of, it can prejudice him in the eyes of black members of the jury.
Mm-hmm. You know what, let's go to a clip and listen to more of this former spokesperson, Mr. Dickerson's testimony, and see where else he goes in terms of what Tex McIver, he says, asked him to do related to the DA's office. Okay, so we were just listening to Mr. Dickerson talk about the fact that he thought that Tex had really gotten himself into some deep water, and a lot of that was surrounded by these inflammatory media reports. And there was some mention of Black Lives Matter, and he thought that was prejudicing him already going into jury selection and going into a potential trial, as he's going to the DA and trying to get rid of all of these charges, right?
Look, there's a lot of cockamamie theories that the defense is throwing around. That being said...
You were just articulating one.
Yeah, you know, look I was sleeping, I woke up, and I saw black people and shot my wife. You know, that's basically the theory of the defense here.
Well, that's why we're questioning what is the relevance of this.
But look, they have established he has a sleep disorder. Mm-hmm. They've also established that as far as the motive the prosecution is trying to deduce, that it was financially motivated. He owed his wife, you know, $350,000. You know, They've introduced evidence that this guy had assets, he had investments, and that he had a legitimate sleep disorder, that he's not, you know, so great when he wakes up.
Yeah, but yeah, you're right. They did establish
sleep studies done in January of 2018, so a little bit strange, but he's a defendant with a lot of resources, and he has a lot of resources to throw at this case. It's a defense attorney's dream to have a client with financial resources that allow you to explore every angle to possibly, exculpate your client.
But then, as we've seen, people who do have this type of leverage or maybe experience or political connections or money to spare could get themselves into trouble like this guy because they try to exercise that power and then it sort of backfires on them. In this case, the witness tampering charges, did you feel that they prejudiced him before the jury? Even though they've now been dismissed, the jury knows about them.
Yeah, I mean, I think this is something that if he is convicted, it could be grounds for appeal. And they might have to do a retrial on it. But,
what about the pretrial publicity? Could that also be grounds for appeal? How prejudicial do you need it to be in order for that to reach that level of appealability?
The press has a right to cover these things going on in the court. We don't do trials in secret in America. We're a democracy. So the press has every right, pursuant to the Constitution, to cover these trials. And I think it's a good thing. I think it's a good thing that the press is in the courtroom in these cases. Quite frankly, I think the press should be in the courtroom in cases in New York because it would make some people behave a lot better. And
it might actually cut down on the pretrial publicity if you're able to cover the actual trial.
Yeah, and I think, look, even though there's a lot of pretrial publicity, courts know how to deal with this. It's not their first time around. Cases have been covered in the news from the beginning that we had a news media. And the fact of the matter is, courts know how to deal with these things. They try to make their proceedings as impartial as possible and to give this guy a fair trial.
So I had heard, just to switch gears for a second, that the defense strategy might be to not even really put on a case, but to just poke holes in the prosecution's case in the form of really emphasizing there's so much reasonable doubt here. But it seems like they are bringing on witnesses to undercut specific statements or insinuations that the prosecution made in their case. So they really are going for that approach of we're going to put on an expansive case here and we're just going to try to knock down every argument that the prosecution made. Do you think they should have just not put on a case and just hammered home reasonable doubt and that would have been more effective? Or should they do what they're doing now?
I think in this particular set of facts, it's a good idea that they put on a case, that they're refuting specific things like the motive, the financial motive. They're showing that this guy had a sleep disorder. He might not have been all there when he woke up. I think it's good. They're poking holes. Some attorneys, they rely on cross-examination during the prosecution's case to poke holes, and in some cases, that is very effective. There was that famous Peter Gation case where he owned the Limelight in the Tunnel. Benjamin Brofman was the attorney for him. He was accused of allowing drug dealers to sell drugs in his clubs, and he didn't put a case on. All he did was cross-examine the government's witnesses, who were not very credible, all had criminal convictions, and he was able to get the guy acquitted like that. But
you have to be so talented, right? You have to be so effective on cross, so strong. Otherwise, it just comes off looking like you're lazy.
You got to be effective on cross, that's true. But there also has to be significant credibility issues with the prosecution's witnesses in order to employ that strategy.
Right.
In this case, the prosecution all had very credible, very trustworthy witnesses.
Except for that one nurse. Who had said something like, "Oh, I hope they get this guy." I'm paraphrasing, obviously, but they.
But even
really
still, she's a nurse. She's
right.
not like someone with a criminal conviction history. She's someone who's licensed in a profession, educated, by all counts, a productive and upstanding member of society. Those are the types of witnesses you want in a case.
Yeah. So you're saying that when you have all of these credible witnesses, you have to dispute what they're saying with your own witnesses or other facts that you can introduce in your case as a defense attorney.
It's very tough to say that these people are lying. They're highly credible and trustworthy individuals. So what you got to say is, look, they're not lying. They're just mistaken. There was no financial motivation. Yes, he owed his wife money. All the time, people in marriages owe each other money. People spend this on their wife spends this on her husband. But this guy had assets, and he was not poor himself. And look, he also had a legitimate sleep disorder that he was not cognitively all there.
Yeah, I feel like you have to prove the sleep disorder. I think that's so essential to why he would have made such a sudden movement when he jerked awake.
They don't have to prove anything. The prosecution has to prove it. But they do have to poke holes and show that there is reasonable doubt here.
But they did essentially prove or get close to proving that there is some sort of, because they established he had a pre-existing condition, and then of course they're bringing on their own witnesses. So technically you don't have to prove it, right? But That's what they're doing. I mean, they're trying to prove to the jury that he had a sleep disorder.
Which is a good thing, because they're going beyond poking holes.
Right.
You know, they're trying to establish facts and introduce their own evidence, which is great. I think the defense has done a masterful job in this case, and if this man gets acquitted, he should send them a card every year on Christmas or Hanukkah.
Or pay them a bonus or a success fee.
No contingency in criminal cases.
Call them and tell them to delete the message after they receive the money. Let's go listen to his former spokesperson, more of that testimony, who he had asked to go to the DA and see if he could do something, get these charges reduced or have them go away. So again, Mr. Dickerson is talking about the fact that Tex McIver had approached him and asked him to communicate with the DA's office. We saw he got like $1,500. Seems like a lot of money to make a phone call to the DA's office. Was that the bonus free?
Look,
I wonder if
we
it's
live in New
contingent.
York City. $1,500 is not a lot of money in New York City.
But
with
maybe
rents
that,
like this.
we don't know. Was that just to make the call? There was some sort of bonus or success fee that was promised. But he just testified when he was asked that he did not offer the DA money to make the case go away.
Well, look, $1,500. First of all, you should never bribe a prosecutor, but I don't think a prosecutor is taking any portion of $1,500 to make a case go away.
Right.
I don't know what they pay their prosecutors down there.
You were bringing up, during the break we were listening to the clip, this old case that Tex McIver had been indicted on.
Yeah,
and why do you think that's relevant to this situation?
Well, I don't know that it's relevant. I wouldn't want to introduce to the jury, you know, it's highly prejudicial. Mm-hmm. But, you know, in 1990, he was indicted for firing a gun, essentially, at a car with 3 teenagers in DeKalb County. And, you know, it's indicted, and the charges got dropped post-indictment.
Right.
Now, any defense attorney can tell you it is extremely rare when a case gets dropped post-indictment. Mm-hmm. Dominic Strauss-Kahn, his case got dropped post-indictment, and his attorney at the time, right before he stepped up to do his press conference, said to his co-counsel, you know, we should soak this in just from a nuts and bolts lawyer's perspective. This might be the only time in our life that an indicted case gets dropped like this.
Yeah, so do you think there was some influence? I mean, we were talking about the fact that he had settled privately with the teens, and maybe they refused to testify, and that put a wrinkle in the prosecution's case. We see that a lot with the victims of sex assault or victims of domestic violence. When they're threatened or when they're fearful or when they're given money on the side, they decide not to testify. The case goes away.
It's very strange, but look, people forget, in a criminal case, it's not these 3 teenagers' case. It's the people of the state of Georgia's case, as represented by that county's district attorney's office. Mm-hmm. And they bring the case.
But do they have a case, I'm saying,
well, it was indicted,
if people won't testify?
So they already had testimony. They already presented the case to the grand jury, and the grand jury indicted. So at this point, they are free, if they wanted to bring this case to trial, they're free to get what's called a material witness warrant and go and arrest those teens and force them to testify at trial. Mm-hmm. But they didn't do that there. You know, it's a little bit strange that in 1990 he got away with making a settlement, you know, with these teenagers, and the prosecutor dropped it.
So you're saying there's a possibility that maybe he used his political influence before, though there have been no charges and nothing to substantiate that.
I wouldn't speculate, but I would say it is highly unusual.
Highly unusual. Okay, so we're going to plant that seed, but we're not making any allegations here because we don't know. I mean, really, there's no evidence that he did approach anybody or that he did try to exercise his influence, but it's something to think about, considering that now we hear from Mr. Dickerson that he's hired somebody. It's for us to think about, not for the
public
people.
To think about,
right?
Not the jurors. Don't let the jurors think about it.
You know what? Not even the public. We'll just think about it. Let's toss to another Dickerson clip and listen to some more of his testimony. And welcome back to the Law and Crime Network. I'm your host, Amy Dash. Let's switch gears for a second as we are on break of the Tex McIver trial out of Atlanta. A prominent attorney who was accused of intentionally shooting and killing his wife, though he says it was an accident. But for a second, I want to talk about David Copperfield, the famous magician. Well, he's facing a lawsuit, and we are expecting the opening arguments to start soon, within the next couple days. So let's toss to a package right now and see the nature of this lawsuit. It's an audience member, a participant in his magic show, who is suing him.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
Well, that should be interesting. Now, we've already seen this famous magic trick. The secrets have been revealed, so we know what happens.
God, we're ruining magic for the kids.
I know, but I found this the most interesting part of this whole lawsuit is what actually goes on. That's what people are always wondering. So apparently he has a whole crowd come up from the audience. Well, first he throws beach balls or something, and then whoever catches it has been selected. They go up on stage, and they're given these torches, which that kind of sounds like a liability in and of itself to have a crowd of people holding torches.
Amy, they're magic torches. They're magic torches.
And then I guess they're put in a cage, and maybe he puts something over the cage, or the stage goes dark, and there happens to be a secret passageway behind the cage, and they're told they have like just a couple of minutes or maybe even a couple of seconds to get through the passageway, and the passageway takes them to the other end of the theater all of a sudden. And I assume they have to like run because this all happens very quickly. All of a sudden the lights go on, or he opens up the cage. Nobody's in it, but they happen to be on the other side of the theater holding their torches, and that's the trick.
Look, which by the way, duh, of course there's a secret passage.
Duh, but you would have never thought of it.
This guy doesn't have real magic abilities. But, you know, he better hope his attorneys have some magic
abilities. Please stop
abilities.
ruining life for the kids.
Look.
Kids like me.
David Copperfield better hope he's got some magic attorneys, because they're going for punitive damages here, which I think is a stretch.
Yeah, well, here's the thing. I mean, this guy's claiming that he suffered a head injury because it's dark and they only have a couple of seconds to get to the other side of the theater, and they're carrying torches and there's so many of them that he suffered a head injury while he was making his way to the other side of the theater.
Look, and I think it's a textbook negligence case, right? Look, David Copperfield had a duty to keep the participants in this magic trick safe. He breached that duty by negligently not ensuring that the passageway they were going through was safe. And, you know, this guy, because it wasn't safe, this guy fell and it caused him to sustain a head injury. Whether or not they can get punitive damages is another story, because for punitive damages, you really have to show that it was gross negligence or that it was intentional conduct. And I don't think you get that here. Look, they were going down a dark hallway. He slipped. Could have happened to anyone. But, yeah, he did have a duty to make sure that hallway was safe.
Yeah, I mean, well, Cox is saying this. He's saying it was dark. There are hands pushing him, so you can't really see where you're going. I think that's a big part of the case, the fact that it's totally dark.
I think Copperfield's attorneys would say instead of hands pushing him, hands were guiding him in the right direction to ensure his safe passage.
Yeah, exactly. And so he's saying he went around the corner and my feet slipped from underneath me and I hit the ground. Do accidents happen if there's a wet spot on the floor? Is that something David Copperfield can control?
Well, look, he should control it. If he's going to be ushering, audience members, participants through, a passageway, he should be making sure that it's free from debris. He should be making sure there's no water spilled or other liquids that someone could possibly fall on.
Yeah. So apparently this magic trick has been performed over 15 years with 100,000 participants. Is that going to help David Copperfield's case, that nothing like this has ever happened before?
No, because just because something didn't happen before doesn't mean he's not liable for the future occurrence of it.
Well, but his legal team is saying, listen, that's exactly what they're saying. Listen, it's been going on for many years. We've never had an incident before. What else can they use to defend this case besides that?
They better use some magic here, because I think this kid's probably going to be getting some money. Maybe not as much money as his attorneys are going for, but I think this guy's liable. I'm surprised it didn't settle.
But of course, he's going to have to show sufficient medical documentation to show a real injury. I mean, he can't just fabricate something like that.
Oh, yeah, absolutely. He's going to have to show that he was injured, that these injuries are affecting his life, and that he's sustaining, you know, some sort of financial loss as a result of these injuries.
So how much would somebody like that be compensated for? Obviously, it depends on the nature of the injury.
It depends on the extent of the injuries. Also, interestingly enough, the age of the injured person is factored in and measured against the average life expectancy. You know, someone who's injured, I hate to be cold and cynical, but someone who's injured at 90 years old, it's a little bit different than someone who's injured, let's say, 10 years old. You know, it's a big difference. That the 10-year-old has a long life ahead of them that they're going to be impacted by these injuries.
Depending on the nature of the injury.
Yeah, depending on the nature.
Yeah, but then you also have people who are older who are a little bit more susceptible. That's why I think it's interesting that they're throwing beach balls out and whoever catches it goes up on stage, meaning that there's really no vetting of who goes up on stage. And you'd think that with this type of liability, when you're involving people who have no experience with magic or magic tricks and they're sort of learning the trick on the fly, that you'd want to screen who the participants are.
Yeah, I also think that it's highly odd to me that over the years he hasn't been sued for one of these tricks. I bet there's a few lawsuits out there, or maybe, you know, pre-litigation they settled matters. I bet some people came looking for money before, but for whatever reason, this couldn't settle.
Now, why do you think, I don't know if he attempted to or not, but why do you think the magic trick was revealed and the court didn't seal it? Let's say he had motioned to seal the trick and the secrets of the trick.
Well, look, trials are supposed to be conducted in a public forum. You know, we like transparency. We don't have secret trials, as I said before, in this country. And unfortunately, you know, his proprietary information regarding how he conducts this magic trick, it's very relevant to the trial. It's relevant.
Right, but
they're going to have to walk the jury through this.
Couldn't it be sealed, though, so that just the jurors hear it and that the public doesn't find out about it? Because this is one of the staples of his career. I mean, he makes a living off of these tricks. He probably only has, a dozen tricks?
Is it anything we didn't know? Did you really think there wasn't a secret passage?
I would have never thought a secret passage.
You think David Copperfield waves a wand, like I waved my hand in front of the camera just now?
You know what? Sometimes it's better to just go enjoy the show and not try to figure it out. Because when you try to figure it out,
then you get a lawsuit.
Then you get a lawsuit. Exactly. You know what? So let's talk more about this Tex McIver trial, which we're on lunch break from. We were just listening to a spokesperson that he had hired, Mr. Dickerson, who said that he had made an attempt to contact the DA, and he was paid money. He said in the last soundbite that we heard that he did not offer the DA money to make the case go away, but he simply wanted to talk to the DA about the case because he felt that Mr. McIver was remorseful. And he felt that maybe that this was an accident, and maybe the DA was leaning toward it being an accident, and he could sort of massage the charges down or make the case less of a big deal.
Which, by the way, that's what I do for a living. That's what his defense attorneys do for a living.
Right.
Why is he hiring this guy who's not a defense attorney to liaise with a prosecutor?
Well, let me ask you about that, because he had a defense attorney at the time. So do you think the defense attorney knew about it? And obviously, defense attorneys can't stop their client from doing something that they want to do. But it seems like he would be adamantly opposed to somebody else getting involved, right? Because you're a criminal defense attorney. I mean, if you got wind of one of your clients trying to hire a spokesperson to go behind your back, it undermines your efforts.
Yeah, and it sends a negative message, too. Look, I've been on cases where there are multiple defense attorneys, and, you know, look, not all the defense attorneys talk to the DA's office. There's usually one point person that handles communications with the prosecutor's office and the negotiations. I don't know why he would employ this other guy to undercut his defense attorney's efforts. You know, it's a bad look. It's even a bad look when a client changes attorneys and then it goes from one attorney to a different attorney. I've seen cases you know, take significant blowbacks when that happens.
Yeah, and you know what? He also, Mr. Dickerson testified that he was going to be offered a success fee, and Tex wanted him to share that information with Mr. Howard, the DA. That's very bizarre.
By the way, that is something very interesting, because in criminal cases, there's contingency fees in like personal injury cases. If you win, the attorney gets money. You don't win, you don't get any money.
Sure.
Criminal cases, you are forbidden from entering into fee arrangements that provide for contingency fees based on success.
But that's with a lawyer you're talking about.
An attorney
right.
would not be able to get a success fee on a criminal case. You charge what you charge, and that's it. It's interesting that he went to this other guy with the prospect of a success bonus.
Yeah, but he was very clear that he never said offer the DA money. And he never said, listen.
Well, he's a good lawyer. He would know never to say that. But it's very strange. And look, I'm not saying he attempted to tamper with a witness or that he attempted to bribe a prosecutor, but it is very unusual. And I would not want a client doing that.
I mean, if they wanted, because you said that the prosecutors overcharged, and we saw that some of the witness tampering charges were dismissed. If they wanted to, could they have built a case for attempted bribery of a public official?
It would be tough because it doesn't appear from any of the evidence that was introduced that there was a quid pro quo, that there was an offer of money in exchange for some sort of benefit here. It doesn't appear that there was anything that explicit.
Yeah, so you can't really go to that third-party broker that we're talking about who would get money, and that doesn't transfer over to the district attorney.
I would be very interested. If they had recorded that conversation with Dickerson, that would be another story. If he had said something that, could possibly be interpreted as a quid pro quo.
Now, let me ask you, what are the guidelines with the district attorney taking the stand related to something like this when they're prosecuting the case?
I would think in a situation like that, they would need a special prosecutor to be brought in from a neighboring jurisdiction. It's such a weird thing that I don't think I've ever seen it happen in my lifetime anyway.
But actually what you're saying is the defense could have sort of flip this in their favor and said, listen, well, if you're accusing him of hiring the spokesperson to go to the DA, well, then we're going to end up having to call the DA, or if the DA is going to become part of this case, we want a special prosecutor to come in. And then you're getting rid of the DA, right?
Yeah, but these charges, largely gone, except for the one that remains, and I think they did a good job at getting rid of them.
Yeah.
Unfortunately, they've got a few more serious charges to deal with.
Absolutely. So let's listen to a little bit more of Mr. Dickerson's testimony. He was a spokesperson that Tex McIver hired to try to influence the DA, however you want to phrase it. Okay, we're back, and you know what? I think the Tex McIver trial out of Atlanta is about to resume. The lunch break appears to be over. I love when we see that braided ponytail by Bruce Harvey. It's always very entertaining to me. It's nice. It is nice, though, when the defense attorney or the prosecution, they have some sort of character to them, a little bit of personality, right?
Well,
some originality.
First off, it's usually the defense attorney that has the character and personality. Prosecutors tend to be a little bit stiff. No offense to my prosecutor friends. I have many, and I love them.
Well, they're working in a different environment, right?
Yeah, it's a bureaucratic environment.
Exactly.
You get bonus points for being rigid. Defense attorneys get bonus points for being creative and really humanizing their clients.
Right? You have a lot of tattoos.
I have a couple
You're from Brooklyn,
tattoos.
and you're telling me you drink the almond milk lattes from the cold breweries out in Brooklyn?
Well, yeah. I mean, dairy is so 1990s, right?
All right. So let's toss back to the trial right now so we can hear the next witness. Is there